يا حبيبة يا فلسطين، بكرة إلك راجعين، والله إلك راجعين.
أتيت بذنبي يا نور فؤادي، وهل ترضى عني وقد فنى زادي. أتيت بذنبي يا نور فؤادي، وهل ترضى عني وقد فنى زادي. هل للمسيء رجاء في رحمة وعطاء؟ هل تقبل الأعداء؟
Costs of service providers and the manner in which EFF funds are expended lie purely within the appellant's knowledge. Despite this, he did not produce a single document to show that those costs had not been inflated, or to rebut the allegation that there were no financial reports tabled since 2014. Thus, the respondent's inability to cite further examples of the inflation of costs for service providers was potentially, at least, a product of the secrecy regarding the accounts of the EFF, which was not rebutted. In the circumstances, in my opinion, and apart from the facts stated in paragraphs 58 and 59 above, the inference, not proof, the inference drawn by the respondent that costs had been inflated was a readily apparent and plausible one. 62. As to the hearsay statement by the service provider, I pause there to say a large part of their challenge to our evidence is that it's hearsay. We say it isn't. I believe Mr. Naidoo will have something to say about that. But apropos a species of evidence such as hearsay being taken into account at this stage, the Supreme Court of Appeal says as the hearsay statement of the service provider, it must be borne, and then there's a reference to the respondent being unrepresented, which doesn't apply, but that's qualified by what follows in 63. The fact that he was unrepresented, the court says, this, of course, is not to say that the respondent was entitled to any better treatment than a represented party. And that's important because that's not a distinguishing factor as to what it's saying. What it says following this is a statement that applies to all parties represented by otherwise. The court says, 64, and this is the ratio, we say, of this part of the judgment. The defense of truth and public interest is founded on the recognition of a right to publish a defamatory statement which is true, where the publication is in the public interest. The facts put up by the respondent demonstrated that the defense was available to be pursued. I emphasize that in a trial in due course, we don't ask for a trial, but if they want to come by way of action, we'll deal with it. And then it says, these facts, the facts put up, sorry, let me just go back. The facts put up by the respondent demonstrated that the defense was available to be pursued. These facts comprise not only direct information placed before the court, but material showing other information not in his control, but potentially available at a trial in due course, such as the EFF's financial records and documents relating to receipt of VBS funds. All these factors must be weighed up in order to decide whether there's a dispute of fact regarding the existence of a defense, since Heldren, the position has been that a final interdict for defamation cannot be granted unless the respondent has no defense. That is our case, Justices. We say that on the application of that dictum from the Supreme Court of Appeal, the interdict cannot be granted because we put up the defense. We've put up far stronger a defense on the uncontroverted information before you namely Mr. Krawitz's connections to these organizations, specifically Karen Highsod, and Karen Highsod's public-facing own publications as to the Missional program and the Lone Soldiers program on their own statements. That is enough to draw the connection, justices, between Krawitz and support for the Israeli war machine and funding it. And with regard to funding, we have not alleged they're a major funder of the IDF. So absent de minimis, which is not an argument raised by Leonard Friends, any funding, any material support for Israel, and specifically, well, let me just disaggregate the submission. Support for Israel, qua a country, is sufficient if Israel is committing genocide. That's an issue you won't determine in this court. That'll be determined by the ICJ in due course, although they have issued judgments so they've issued 3 rulings beginning in January 2024, finding plausible grounds for genocide in the case that South Africa has brought to the ICJ. And we know that in reply, they say they're prepared to deal with this matter on the basis that our allegations of genocide are at least plausible. So on that basis, support for Israel, expressing a love for a country that is committing genocide, involves supporting the genocide, being associated with Israel, and we submit, in line with our constitutional values and the case law you have, gives us the absolute right to protest against Mr. Krawitz, and the most public manifestation of Mr. Krawitz's operations in the country, which he takes pride in, which is his business. Happening in Mart is Mr. Krawitz's business. As a separate species of support and funding, if we want to be particular and go to the military. So the mere statement in January or in the interview where he says, should I consider suing them? And then I thought to myself, well, do I really want to say, and these are his words, we played it to you so you could hear it. Do I really want to say that being associated with the IDF is defamatory? That wasn't a rhetorical question by Mr. Krawitz. That is Mr. Krawitz not thinking that eventually those words will be heard in a court of law. That's an unguarded moment. That's Mr. Krawitz being Mr. Krawitz. And Mr. Krawitz's view, we know. And we fully accept that the test for defamation is objective. It's not subjective. So Mr. Krawitz's views as to whether he's being defamed or not by being associated with the genocidal army is relevant. But the point of the matter is we know that Mr. Krawitz does not consider it defamatory to be associated with the Israeli army, even if it's committing genocide. Now, he's entitled to his views that being associated with the genocidal army is not defamatory because our constitution allows him to have that view. That is the beauty of our country and our constitution. But we have the right, our clients have the right to condemn him for that. And when he says it publicly, we have the right to go to his business and say, you are a supporter of genocide. And that is the right we exercise. Now, just to close this point off, my learned friend made much, and he referred you on a number of occasions to the minority judgment of Rogers J, which you find from in Malema versus Rawula from paragraph 67 on. Now, both Skippers and Rogers J.A. and our Justice Rogers in the Constitutional Court are eminent former judges of this division. But with the greatest respect...
Are you telling us that as if we don't know that? I would happen to be appointed at the same time as both of them, so I'm going to take judicial notice. Thank you, Mr. Jamie.
And we both shared university lectures with Justice Rogers. The point being, Justice Clitty and other justices, is Justice Rogers is wrong in this case. because Justice Rogers's approach is diametrically opposed to what I've just read to you in paragraph 64.
Mr. Jamie, it's not about who's right and who's wrong. We are bound as a high court by the majority decision of the SCA in this particular matter.
That's the end of the matter. Well, I don't need to, but I am responding because he urged upon you paragraphs in Justice Rogers's judgment. But if the court approaches on that basis, then
I think if I don't know what the law of precedent is, Bernard, it's too late to teach me. I must just go off into the sunset and surf.
Justices, can I finish the factual? Then I'm going to effectively conclude an argument. If the court will just permit me, I'm just trying to see where I was.
I can tell you exactly where you were. You were on paragraph 158.
158.
That's where we
so
you can just carry on from there.
In front of me, thank you, Justices. And then on the next page at 944, from paragraph 159 and onward, down to 163, we refer to Mr. Krawitz serving on Karen Household's international governing body as a campaign executive. We say in paragraph 160 he became directly involved with Jaffe. And we say, although formerly independent, Jaffe is another of Israel's national institutions, established by law to collaborate with the state. Jaffe focuses on immigration, settlement, and diaspora relations. Historically, it played a central role in establishing and expanding Israel, including settlement activity. We say that the two organizations are intertwined with Jaffe. Well, we say two things in paragraph 162. More than 50% of funds raised by Karen Household are earmarked for Jaffe. And Karen Household
Mr. Jamie, perhaps in the interest of time, you could just give us the paragraph numbers without reading out every paragraph.
It's 159 to 163, Justice.
Yes, and then?
And we say that he sits on the Board of Governors of Jaffe.
So it would actually be 159.
All the way to 163.
Further on your evidence, right down to 172.
The actual activities
174.
The actual activities of Jaffe are quite great.
174.
Goes all the way down to 168. And in fact, sorry, you
174.
All the way to 174.
Okay, thank you.
I just want to, I'm going to come back to, I just want to make submissions about two aspects of that account relating to Jaffe and Talfed. Talfed is dealt with in 168, at paragraph 168, Justices at 946. And Talfed is the popular name for the South African Zionist Federation in Israel, which we say assists South African immigrants in Israel and recruits South Africans to serve in the IDF. So a direct assertion, and we say it's to be found, the proof of that it's a recruitment, that it encourages recruitment or recruits South Africans to serve in the IDF, we reference as UC 50. UC 50 is to be found, Justices, at 9741. And what we say is a recruitment poster is to be found at /770 to 771. So this is page 30 and 31 of the Talfed document, which is a you find it begins at 970, UC 50 begins at 741, and it's a fairly lengthy.
If you just give us those specific page numbers, please.
770 to 771.
Are those the ones that you said that we will find it at?
Yeah.
Thank you. 770 to 771.
Yes.
Thank you.
Headed why you should draft to the IDF. I won't take you to it.
Thank you.
The last reference I want to give you relates to Jaffe, and it's to be found in reply. And I'm going to be very brief with this. The court's aware that in reply, they say we've misconstrued Jaffe. Jaffe is...
May we accept that this doesn't form part of your, this particular portion doesn't form part of your striking out application?
The striking out application with regard to...
There's an application to strike out material in reply. I just want to make sure that it doesn't form what you're referring us to now isn't part of the striking out application.
I'm advised by
Okay.
Advocate who's dealing with the...
But it doesn't.
It doesn't.
Okay, all right, thank you.
The Jaffe document that is relied upon by the applicant to show that our characterization of Jaffe is simply incorrect is the document at 10-154, it's R19. And what they say is that if one has regard to that document, it's apparent that, and if I could just give me one moment, Justice. You'll find the relevant paragraph at 302 of the reply at 1071, where it is asserted, and this is the last factual submission I'll be making to you.
Sorry, paragraph?
Paragraph 302 of the reply.
302,
302 of the reply, 1071. They say the following, they attach in 301, they attach the agreement for the reconstitution of Jaffe, and they say that, and then at 302, they say, I highlight the following from that document. Jaffe explicitly does not perform any work in respect of activities and facilities which the government of Israel is law obliged to furnish. And then they say, rather, Jaffe performs the following, and then in parentheses, non-governmental, close parentheses, functions, and then they list it. Now, if one goes to R19, which is a document in support of that assertion, you will see that there's been a misquote, or not a misquote, there's been an insertion of the words that you find in paragraph 302, non-governmental, those words that you find 302, 1071 are not to be found in the document that you find at 10-156, which has been quoted from. So if one looks at the actual reconstitution document that's been quoted from beginning at 10-154, but when you look at 10-156, para C, 1C, it doesn't have the words non-governmental. That's the first point. Second point is if you look at the actual things that Jaffe will undertake, the functions it'll undertake. And in construing this document, we're going to do so as a document, and therefore in domini, Batopele, etc. as well. So I'm going to be brief on this.
No, I was just wondering if you were going to explain in domini to us as well as you explained Plascon Evans to us yesterday.
I'm sorry, explain.
I'm teasing you. Get on.
So when one looks at 1C, it says, except with respect to, and I ask you just to note the words activities and facilities. It's not functions. It says, except with respect to activities and facilities, not functions, which the government of Israel is by law obliged to finish, obliged by law to finish, i.e. in terms of possibly common law. I know nothing about Israeli common law, but more likely statute. But let's say it covers any sort of law. Except with respect to activities and facilities, which the government is by law obliged to furnish, Jaffe will undertake the following, not provide facilities and services, but undertake the following functions. A far broader word and concept than providing facilities and activities. And these are the functions of Jaffe on his board of World Board, along with 119 others, Mr. Krawitz sits. These are their functions. Immigration to and absorption of immigrants in Israel. Social welfare services in connection with immigration and absorption. Health services in connection with immigration and absorption. Education. not limited to education, to immigration and absorption. Institutions of higher learning and research, not limited to immigrants. Youth care and training. 7, fostering regional development and creation of centers of employment in peripheral areas for the absorption of Olim, which I understand, but I'll be corrected if I'm wrong, are immigrants, and for their social and community integration in urban and rural sectors and absorption in agricultural settlements, immigrant housing. The submission that we make based on that is these are quintessentially governmental functions. This is what governments do. This is not what some charitable organization that stands totally different and totally removed from the state and the government and the authority of Israel does. They do not undertake, not provide input, not make recommendations, that undertake the function of regional development. That's either, in our language, if that's not, well, my principal submission, these are governmental functions. Jaffe is an agency, and it undertakes integral parts of what anyone would consider the governmental running of a country. That is what Jaffe is. That's what we say Jaffe is. We may be, but I don't have to prove that to you. We don't have to prove that to you in this case. If called upon to do so, we will prove it in a trial. That Jaffe is an integral part of the Israeli state, that Keren Hassad and Jaffe support that state. Mr. Krawitz, by his position on both organizations, is part of the Israeli state apparatus. At minimum supports it. He funds genocide the ways that we asserted. Our speech to that effect is accordingly substantially true. It's never been in dispute that if found to be true, it would be in the public interest. Clearly engages an issue which is of enormous public interest and concern. And we should have the protection of the law and the Constitution in making those assertions. We do not have to, we accept the LaRue versus Day onus, but that is not an onus we need to acquit ourselves of in these proceedings. The onus is the evidential burden that we attract is set out in paragraph 64 of Malema versus Rawuda, and we've discharged that overwhelmingly. This court would not be justified in dismissing and finding that we've set up no defense as per Helbrand. With regard to comments, we submit that statements such as killing children are precisely analogous to, let us use another example, and I'm aware that example is supposed to be treated in caution, but to use an example, during the heyday of the protest over HIV medication and the government's refusal to provide that to South Africans, hundreds of thousands, well, let me not say hundreds of thousands, many pregnant women, many children died or suffered enormously adverse medical results as a result of the government's position, which many of us regarded at the time as irrational, had no scientific foundation, that led to children and women dying. If South Africans, and they did, in fact, they did take to the streets, labeling the government murderers. So if South African protesters had then protested against the government's position by holding banners outside the Union building saying, Mbeki is a murderer, I make two submissions in that regard. One is, undeniably, indisputably, that would have been within their constitutional rights to say, to make those utterances, to have those protests. The second is that if President Mbeki then sued those protests in a court of law, they would have said, and he said, but I'm obviously not a child murderer. I've never touched a child in my life. It's obviously competent. No one would sensibly understand that as saying President Mbeki goes around killing children. That is the context, and any sensible person would understand our comments, our clients' comments about baby killers, K killers, KWA killers, etc., as being precisely that. They comment, they're robust comment, they are harsh, condemnatory comments, but my clients believe that the tone of that comment, of those comments, is entirely justified by what is happening in Gaza at the hands of Israel, but they are cognizant that that does not mean that they can level those accusations at anyone, which is why, despite there being hundreds, if not thousands, of Jewish-owned businesses in this country and the city, we've not gone to protest outside any one of those businesses, because our client's position is that we have nothing against Jews. This is not an anti-Jewish protest, despite what Mr. Krawitz says. It's directed at his Zionist activities, at his Zionist beliefs. And can I just qualify that submission? When I tell you Zionist beliefs, it's his Zionist beliefs and his Zionist associations as published to the world. Mr. Krawitz is entirely at liberty. Our constitution allows that for him to have whatever beliefs he wants privately. But when he enters the public realm, when he's the public face of a large business, as he says he is, as the founding affidavit says he is, then with that comes accountability. And if you profess a position which you honestly hold, well, we respect you for holding that, but then you must take the consequences. And these are the consequences. We're allowed to protest against them. My final submission, Justices, is that if one looks at the order granted, even if you were to be against us, Justices, of all arguments, when you come to the order that's being sought, it simply isn't the sort of order contemplated in MIDI, in print media, in the other cases that we submitted to you. It is, and we don't need to get into the realm of can you grant it or republication, etc. This is a gagging order. If you look at it in its terms, it's a gagging order. And I've not been able to, and my very diligent juniors have not been able to find any case in our law where this sort of order has ever been granted. I made the submission yesterday that if you, after careful analysis...
You made it yesterday.
No, but this is just really my final submission. I promise you. If you were to, after careful going through the different publications that we take responsibility that are ours, not someone else's, but ours, on the papers, applying classic on evidence. Once you've done that, let's say you find 5 things that we've said which fail the test that we've set up, and those are properly laid at our door. The question then is what relief to be granted. It could never be this.
Are you saying that it's 6 or nix then?
It's 6 or
nix.
Yeah.
So if we don't give them exactly what they're asking for, the application must fail.
No.
We are not at liberty
No,
to craft something in between. I just want to make, and to understand your submission on that.
No, I've made it unclear. Let me make it clear.
Mm.
If you were to find publication by us and we fail,
yes, I'm just taking what you said now
then
further.
You could order. You may not publish poster UC whatever, poster the annexures, whatever the annexures.
So to cut through this, you're not suggesting that this court is not at liberty, if court ultimately is not entirely with your clients, to craft a narrower order or an order of narrower application.
Yes, but just without...
It's not, when I say 6 or nix, it's not either we grant them what they're asking or we refuse them entirely. Then we're on the same page. Thank you.
But the nature of that order and the premise of the order must be clear, Justices.
Thank you, Mr. Jamie. We'll try and bear that in mind.
Can I just, this is very important to our case. Can I just
very important to us too, because we're the judges who have to give the order.
I know.
So we generally do try and apply our minds to the efficacy and certainty of our orders. And we will continue to do so. Maybe not successfully, but that will then be pointed out to us.
The purpose of my submission, Justice, is not to suggest otherwise. It's simply to, as I understand my function, to make submissions which will assist the court.
But you took us through those paragraphs yesterday in great detail.
I just want to make submission of principle with regard to any such order.
After the lunch adjournment.
Yes. I wish to make a submission of principle with regard to the nature of any order that you can make.
Okay.
It can never be an order that says we may not publish category of statements, which is how all of these are touched. It can only ever pertain to identify and not future identify things that we may possibly publish in the future. It can only, that's the whole point of the internet, and as I said yesterday. So in LaRue versus Day, you may not publish that image again. In Manual, you may not say the thing, you may not put up that Facebook post again. That is how all these cases, where there were orders, that's what the orders were. You can never say that you may not publish a category of speech. That is a gagging order. It's quintessentially a prior restraint. This court, and we are not aware of any authority. I invite my learned friend to give you authority where a species of speech has been forbidden a priori by way of a court order. That is quintessentially not what a court will do, without totally trampling, sorry, not court, but without ignoring the rights of expression. Those are our submissions. We submit for all those reasons the application falls to be dismissed with costs, including that.
The cost of 2 counsel on scale C.
As the board faces.
It's one thing you all always agreed on. You must all be
We did have 3 counsel there.
given the highest scale of costs.
We did have 3 counsel there. So
it doesn't mean you're going to get the cost of 3.
as the board faces.
Mr. Jamie, I haven't finished.
I'm terrible.
I would like to ask you to give consideration to this over our long overdue tea adjournment. Paragraphs 1 and 2 of Masuku.
Of the order.
No, of the judge.
Oh, it was, sorry.
Yes.
Paragraphs 1 and 2 of the suit.
I think I have to raise this with you in fairness to you, given your argument, and I don't want to not give you that opportunity.
So, sorry, I'm just trying to find the suit.
I'll read it.
Oh.
And then you can find it, and then maybe just deal with it briefly when we return before Mr. Naidu starts.
Certainly.
And I'm just going to read it because, to me, it goes really to the heart of, in a sense, of what this argument and this debate is about. And given what I accept now, you accept, is our understanding that we are bound by the decisions of higher courts, I thought, in fairness to you, I should maybe just mention it and you can deal with it.
Certainly.
So it starts off, this is a matter between the South African Human Rights Commission on behalf of the South African Jewish Board of Deputies, Mr. Masuku, Kosatu. The first amicus was the South African Holocaust and Genocide Foundation, and then there were various other amici as well.
Sorry, if I could just try to follow you in just trying to find, I think it's in my learned friends bundle.
Yeah, I don't know. I have my own one. So,
no, carry on.
Okay. So
sorry,
it starts off
yes,
with the following passage. At the heart of this matter are 3 fundamental rights, all indispensable to any healthy constitutional order. These rights, the right to equality, human dignity, and the right to freedom of speech and expression, are rights that carry unique and troubled pasts interwoven into the fabric of apartheid history. In this constitutional dispensation, they are inextricably interconnected with what it means to be a citizen of a democracy, free to live a life in a condition of dignity and humanity. In this matter, these rights meet each other. And I think we're dealing with a similar sort of,
yes,
of case.
yes.
Paragraph 2. The background to this matter is disturbing, and the genesis of the legal question with which this court now finds itself seized, lies in 4 statements made orally and in writing by Mr. Bongani Masuku in respect to the protracted feud between Israel and Palestine in the Middle East. It should be said at this earliest opportunity that what this court is not called upon to do is make any pronouncement on that situation, which is a concern of international relations and not a justiciable issue. To pronounce on this situation would be both wholly inappropriate and totally irrelevant to the legal questions that are the objects of our attention. Now that any ambiguity as to what we are doing here has been eradicated, let us turn to the background of this matter, the reason we are here. So maybe you can just deal briefly with why that approach in this matter is inappropriate when we return. It's now 11:25. We'll be back at 20 to 12. Thank you.